Chapter 13, U.S. Courts. Chapter 13, Learning Objectives. Illustrate the typical hierarchy within the state court system and the federal court system. List and describe the various types of specialized courts operating throughout the United States. Explain what our adversarial system and justice is based on and what it requires. Identify the key players in the judicial process. Understand the critical stages in the criminal justice process and the order in which they typically occur. Summarize what the alternatives to the trial are. Discuss the significance of the Giglio decision for law enforcement officers. Jurisdiction of court. So you look at the jurisdiction. This is basically talking about the jurisdiction of the court, and you have the original jurisdiction, also the court, and you have appellate jurisdiction. When they look into the appeals process, adjudication, when you have a case where it's been fully adjudicated, meaning a person has been found guilty and it has run its course through the courts of appeals. Trial courts is where you have the courts where individuals go when they've actually agreed to go to trial instead of take a plea. Courts of last resort, this is going to be your highest courts in the land. In the United States, that's going to be Supreme Court. In state courts, that's usually like the state Supreme Court. The state court system, most cases originate in municipal or county courts. So you see that in the areas in which most people live, in municipal and county courts. Res patria, the state is responsible for the general prosecution, protection of people within its jurisdiction who cannot protect themselves. So that means that the state, this is Latin for it means that the state is responsible for taking care of people, its citizens. And you petition. A petition is something that you have that usually you've heard it before. It's a piece of paper where multiple people have signed for something, usually trying to advocate for something or advocate against something. A disposition hearing is when it goes before a judge to actually hear, to review the sentencing. After the sentencing stuff, to take a look at that to ensure that the person was actually properly sentenced and there was no issues. Adjudication hearing is when it comes back to when actually the judge is listening to everything has run its course and the judge is looking at the charges that were filed and what the conviction was of, and to make sure that everything was properly charged and properly adjudicated. Emancipated minor. This is when a minor goes before a court in some state jurisdiction and they petition the court to get emancipated from their parents or legal guardians. Usually when you see this, it's because of some type of alleged misconduct on behalf of the parents. Four-tiered system: magistrate courts, district courts, appellate courts, U.S. Supreme Courts. And when you look at the four-tiered system, the magistrate courts is where people go when they usually get arrested initially in the early proceedings in the court. District court is where they go when they say that they're actually starting a legal proceeding, like a trial. Appellate courts is where individuals go, defendants go, their cases go after, let's say they go to district court to get convicted of a crime. Well, if they want to appeal it, they appeal it to the appellate court. And the appellate court will review the case and determine if the case was properly investigated, properly, or the sentence is correct. Or they can overturn it. U.S. Supreme Court, if the appellate court determines that the case was actually, everything was done right, then someone can appeal it to the Supreme Court. But they have to file a writ with the Supreme Court to get it appeared before the Supreme Court. And the Supreme Court accepts it, then they will go ahead and hear. If not, they will actually refuse it, and the appellate court's ruling will be upheld. Tribal courts. Hear cases pertaining to Native American law. So realistically, in the continental U.S., you have tribal courts. This is where it's on Indian land, like Indian reservations, Native American reservations, and they have their own judicial system. They have their own law enforcement and judicial system. And in that, this is where they go to trial and stuff under tribal courts. Community courts. Now, when you have these community courts, a lot of times this is courts where you have it in areas where they hear things that's particularly important and pertaining to the community. And these are legal binding things that happens. A lot of times they will pass sentences and do things to get things expedited. And this is just another way of keeping things out of big court. It is not very common. I've never seen one of these before, so there's only 3 dozen throughout the country. And a lot of times you're dealing with things like quality of life issues, with people doing things in the community, affecting people's quality of life. A lot of times they're crimes, but it's almost like knucklehead stuff that they're doing. Problem-solving courts seek to achieve tangible outcomes for victims, offenders, and society, more than 3,000 nationwide. So when you look at the problem-solving courts, you look at drug courts, driving while impaired courts, domestic violence courts, mental health courts, homeless courts, reentry courts. Reentry courts are going to be for people who are actually coming back in and out of prison. Teen courts and youth courts, and juvenile courts and gun courts. So when you look at this, you have all these different types of courts right here. And again, because the court system can get so convoluted, these are ways to actually deal with these things in a manner where you don't have to go to district court. The adversarial system. So in the United States, our legal system is the adversarial system. So when you have a legal proceeding, you're always going to have someone who's the accuser versus the accused. Now, the accuser could be the state. It could be the state, it could be the federal government, it could be the county, it could be city, or it could be another person. You have a presumption of innocence in the United States. So it basically means that all people are assumed innocent until proven guilty. Reasonable doubt. Reasonable doubt is something that sets in when there's a possible chance that they did not do something. And so if there's a reasonable doubt, then there's a high probability that this person is somebody who would not be convicted in a court system. Preponderance of evidence. This means that they were more likely than not that they did it. And this is what you will find in civil courts. Reasonable doubt is what you're going to find in criminal court. Preponderance of evidence is what you're going to find in civil courts. And this could be where 2 neighbors are suing each other over some type of dispute. So the preponderance of evidence means, is there a 51% chance that the person did it versus 49% chance that they didn't do it? Key players in the judicial process. You have the defendant, you have the prosecutor, defense attorney, public defender, pro bono work, ombudsman. So defendant, that is the person who's being charged. The prosecutor is the person who's actually seeking justice to prosecute the defendant. Defense attorney is representing the defendant. You have a public defender. When they can't afford to represent themselves, a public defender will represent them. Pro bono work is when you have a attorney who's representing the defendant for free. Ombudsman is someone who's appointed by a court system to investigate some allegations and to look into it, and a lot of times to see how the things may get settled without maybe going to court. Judge is someone who presides over a legal hearing. Jury is the people who are selected to serve on a jury. And when you have the jury, you usually have 9 members, civilians from the community who serves on the jury. Sequester. A sequester is when you have, usually in high profile cases, when the judge says this jury is going to be sequestered. So that means the jury is going to be staying somewhere that the government says they must stay. They can't leave. They don't want them to watch the news or TV, anything, or read newspapers pertaining to the case. The grand jury is a secret panel of civilians who are selected to serve on a grand jury and listen to criminal complaints about individuals. And based upon the criminal complaint, to seek an indictment, you have to get a grand jury to listen to it. And that means if they listen to it and they say there's probable cause after they listen to it, then they'll go ahead and give a true bill. That means everybody on the grand jury says, okay, it is a probable cause that this individual committed that crime. The coroner's jury, this is a group of people who is sent on a coroner's jury, and they will review evidence to try to determine what was the cause of death for an individual. Critical stages. So at the criminal stages, you have a crime. Once a crime happens, an individual commits a crime, of course, you get an investigation. And so let's say you have investigations being conducted, and now law enforcement signs an affidavit, goes before a grand jury, and gets an arrest warrant, or they go before a judge and swear under oath and get an arrest warrant. Once they get the warrant, then they can arrest the individual. Once the individual has actually been arrested, then they go through booking. Booking is where they're processed to go into jail. Once they go into jail, they've been booked. The first thing happens for them is they get an initial appearance. An initial appearance is basically where they go before a judge, and the judge wants to establish basically their name and also the charges against the person. If it's a person who has not been very violent, regardless, they may get a bond, they may get a bail. They may say, okay, your bail is $10,000, and they have to come up with 10% of that, so that would be $1,000. Charge and decision complaint. This is the charge and decision complaint is what actually happens. Law enforcement prepares that to get the warrant. You have your preliminary hearing of grand jury. So preliminary hearing, judge determines whether there is probable cause to think an offense has been committed. So in the preliminary hearing, they would say, okay, probable cause there, so this individual is going to be remanded to jail or the charges will stand up. You have the outcomes, whether they are actually convicted or dismissed. You have that, the dismissal. Present information. So they're taking a look at all the information that's involved in it. And based upon that, they'll determine whether or not this individual is actually, this legal proceeding how it should go. Send the case to the grand jury. So they can also send the case to the grand jury for the grand jury to actually listen to it to determine whether or not probable cause has been established. And if so, seek a bill of indictment. Okay, when you have your arraignment, this is where the individual, when you're looking at having an arraignment, where the charges are brought up for this individual to starting a trial. Standing mute. This is where an individual chooses to not utter a word and pleads to fifth by basically being silenced. And a no contest plea is basically where the individual says, I'm not going to say plead guilty or I'm not guilty. I'm just taking no contest. And that basically agree with the terms of the conviction. Guilty plea is when the individual agrees to plead guilty, usually for a lesser sentence, because they know that they're overwhelmed. There's overwhelming evidence against them. If they get convicted, they're going to serve a lot of time. Discovery is what you have is when individuals, when they have investigations been conducted. So you have law enforcement and the government would actually have discovery. What they have to do is to turn all their evidence over to the defense attorney and the defendant under discovery so they can see what the evidence is against them. You have your pretrial motions. Your pretrial motions is where they come in and they may defense may file some. There may be motions filed for various items for the case. For instance, you may have a pretrial motion where someone a defense attorney files a motion to dismiss the trial based upon a certain belief. Plea negotiations is when individuals, the defense and the prosecutor, they sit down and they negotiate a plea. Basically, they agree that they don't want to go to trial. Both sides agree they don't want to go to trial, but now they got to agree on what the sentence may be, what they agree to. Trial is what they go to if they can't negotiate and come to a plea. Sentencing appeal, once someone gets sentenced, then they may try to appeal their sentence, saying they think it's unfair, unjust. Diversion. This is bypassing criminal justice system by assigning an offender to a social agency. So you have some instances where some individuals will be better served by not going to jail, but might be getting help by some agency. A lot of times you think of people like maybe a drug abuser, a drug addict. Provides expansion options with which to respond to criminal behavior. So they have different ways to respond to these ways to help these folks, and without maybe going to jail. Types. Prosecutor won't press charges if the program is completed. So if a drug addict goes to this program and completes it, then they won't press charges against them. Prosecutor suspends charges and drops at completion. So once they've completed and they've been signed off on, to come back before the judge and stuff, and the prosecutor will drop the charges because the person completed like a drug rehab. Guilty plea is dismissed if the program is completed. So again, they're working out deals with these individuals to get charges dismissed. Impossible overload due to overcriminalization. So a lot of times you have situations where you have impossible overload of this type of system due to overcriminalization. And because of that, this system right here actually I mean, it exists because of the overloads of criminal mobilization. Plea and charge bargaining. Legal notifications between the prosecutor and the defense attorney or the defendant to reach an agreement or compromise that avoids trial. So this is another way to avoid trial. And look, disposes of 95% of cases. A lot of cases do not go to trial because the bottom line, they're disposed of. There's some type of plea negotiation worked out beforehand. A bench trial. This is when the defendant had agreed to have a trial and only the judge is actually going to listen to the evidence and render a ruling at the end, guilty or not guilty. Jury trial. A jury must be selected and a selection of fair and impartial jurors from the community, and they will hear a case. And these 9 people will determine whether or not someone is guilty or innocent. Testimony. This is when you have individuals for the prosecution and the defense who get on the stand under oath and give their testimony about what transpired. Cross-examination is when you have the defense that will cross-examine, the police officers get on the stand, and you have the prosecutor who would cross-examine any defendants that get on the stand. Closing statements and jury deliberation. So closing statements when each the prosecution and the defense will get so many minutes to make an argument, to close their arguments as to why the person is guilty or not guilty. Then afterward, all the evidence goes to the jury for deliberation, and they will render a ruling, a verdict of guilty or not guilty. Now, there's another thing they can do. They can have a hung jury, and that means that of the people on the jury, one or more has said that I don't think he's guilty, and the other one said they're guilty, but at least one person says they're not guilty, then you get a hung jury, no verdict. Sentencing. After a person has been determined to be guilty, then they will be sentenced, and they will come back to court for a sentencing. They set a date specially for that. Continuing from probation to intermediate sanctions with jail, prison to death. So when it comes to this, it can be all types of things they can be sentenced to, depending upon the type of crimes they committed. So sentencing guidelines. Each state and the federal government has sentencing guidelines, and it says if you commit certain crimes, they can go in a book and look to see how much time you should be sentenced to. Policy to alleviate disparities. So one of the reasons you have the sentencing guidelines is so that you have some type of consistency. So you don't have one guy who commits a robbery and gets 3 months, and another guy commits the same robbery and gets 3 years. Has not done so, and even though that this is designed to do that, in a lot of cases, it has not been that way. You still have had some issues where there was inconsistent sentencings. 3 strikes laws, mandatory minimums, and truth in sentencing. So when you have the 3 strikes laws, the 3 strike laws basically says anytime that you have somebody who's committed a crime on 3 separate occasions, and they've been to court 3 separate times, been sentenced 2 times before, the 3rd time, 3 strikes, you're out. And sometimes, in California, if that's drug trafficking, then that could be on the 3rd strike, then this person gets life. Mandatory minimums, it says if you have people who commit a certain crime, they get a mandatory minimum of so many years. So that's usually in the sentencing guidelines. So case review and appeal. So when you have a case review and appeal, this is where someone's been convicted, they've requested a case review, and then they file appeal. And it usually goes to an appellate court, what we talked about earlier. The police officer in court usually helps establish elements of the crime by testimony and evidence. Preparing a case for prosecution. Must prove the case beyond a reasonable doubt. Pretrial conference. All evidence is reviewed. Appearing as a witness. Diminuous communication. So bottom line is they're there to communicate and give out testimony about what they see or what they were involved in. Officers must always tell the truth. Giglio information. This is if you have a police officer that they've been documented on being dishonest or lying somewhere during the course of their career, then that information is supposed to be, it's what they call giglio information, and that's supposed to be presented to the court. This information can be used to impeach an officer's testimony. Basically, if he lied about something 2 years ago, then what makes you think he's going to come here and tell the truth today? So his testimony could be impeached, and he could be damaged very severely by doing that. That concludes this chapter.